Hello, I am Sandhya Rohar, Assistant Professor at Department of Laws, BPS, Women University, Sonipat. Welcome to today's lecture on Chapter 27, that is Legislative Relations between Union and Parliament. It is like before start to the lecture, I would like to give the brief outline of my lecture. Number one, I'll give the introduction about the Indian legislation system. After that, what are the legislative subject matter will be explained by me as the subject matter of laws made by Parliament and by the legislature of states under Article 246. After explaining Article 246, I'll come to the Article 248, which is known as for residuary powers. Now, after discussing this, I'll explain you the situation where if there is inconsistency between laws made by Parliament and laws made by legislature of state, and I'll give you the solution of such problem. After discussing this problem and solution, we'll come to the test to check the repugnancy between the laws. My next discussion in the lecture will be about the Parliament power to legislate on state subject, and here in my lecture I divide this power into 4 categories under the Article 249, Article 250, Article 253 and Article 356. We will discuss these articles in detail during the lecture, and after discussing all this, I will sum up my lecture. And my dear student, on completion of lecture, you will able to state that what is the name of the list on which only the Parliament can make laws. After that, who can make laws on the subject mentioned in the state list, and we will also able to state that how many states can request the Parliament to make law on the some subject mentioned in the state list. So dear student, come to the introduction portion of the legislative relation between Union and Parliament. Firstly, as the Constitution, or we can say Constitution of India, in its very first article describe India as a union of states. When the British power was established in India, it was highly centralized and unitary. And you know that in the Constituent Assembly, the drafting committee decide in favor of describing India as a union. And during the last half century, many structural changes have been made and the map of the union of states reshaped now. So student, here I will discuss the distribution of legislative power, which is based on territorial legislative subject matter in the legislative subject matter. As Article 245 of the Indian Constitution is talking about the territorial legislative jurisdiction, and the opening words of this article is extent of laws. The word extent here is indicating limit to make laws. Here clause 1 of Article 245 divides the territorial power to make law between the Parliament and of course the state legislature. Now, to give the more clarity of the union and state in a relationship, I would like to compare the whole body with its parts. Means here I would compare the union and state as the body and its part. You know, the State Reorganization Commission report concluded as this relation in the words we can say, it is the Union of India which is the basis of our nationality. States are but limbs of the Union, and while we recognize that the limbs must be healthy and strong, it is the strength and stability of the Union and its capacity to develop and evolve that should be governing consideration of all changes in the country. So here the relationship between the Union and the state is a relationship between the whole body and its part. And as we know that body being healthy, it is necessary that its part should be strong. It is felt that the real source of many of our problems is the tendency of centralization of power and of course misuse of authority. Okay student, Indian legislation system, as we already discussed it, but here I would like to compare this Indian legislation system with the other countries' legislation also. Firstly, I'll explain you the Indian legislation system with different manner. That is, the Indian federal system has two levels of governance. One national level government and the other is state level government. And here again this level is along with the separate legislative power between the center and state. It is allocated by the constitution. There is a separation of power, and the Indian constitution may provide for a more concentration of power on the central government. And as we all know that India is a country where is a multi-party system, and this system has various impacts on the center-state relations, and it resulted in unstable, weak government at the center many times. Now, I would like to compare this Indian parliamentary legislative system with the Northern Ireland legislative system. Firstly, the Northern Ireland Act 1998, the section 5 of the Act provides for the making of acts of the Assembly. But it reserves for the United Kingdom Parliament the right to make laws for the Northern Ireland, subject to the right of the Assembly to modify provisions made by the Act of Parliament in so far as it is a part of the law of Northern Ireland. Now it's section 6, clause 1 of the Northern Ireland Act 1998, who states that a provision of an act is not law if it is outside the legislative competency of the Assembly. So students, here again I would like to compare this Northern Ireland legislative system and Indian legislative system with the Scottish legislative system. Now, to explain the Scottish legislation system, I would again like to tell you about the Scottish Parliament has the power to make act of the Parliament which should be within the sphere of the competence. It is laid down in the Act, and any act which is outside the legislative competence of the Parliament is not law. Here, to make it more clear, we have to discuss the section 28, clause 7 of the Act, which make clear that the legislative competence of the Scottish Parliament does not affect the power of the Parliament of the United Kingdom to make laws for Scotland. And again, section 29 stipulates that an act is not law if it is outside the Parliament's legislative competence. and state that a provision is outside its competence if it relates to the law of a country or territory other than the Scotland, or we can say if it relates to the reserved matters. And the last restriction is about the breach of the restrictions given under Schedule 4. So, here after discussing the comparison, we can conclude that the law which is against the competency of the legislature is not valid at all. Now, after discussing the comparison of the Indian legislation system with different countries, I would like to give the effect of Indian legislation. As you know that Article 245 of Indian Constitution also includes the power to make laws by Parliament and state legislature to give effect to the enacted laws prospectively as well as retrospectively. And to clear this, I would like to state a case. Before stating this case, I would also highlight one point, that the legislature has power to alter the existing laws retrospectively also. And the name of the case which I would like to mention here is Yadlapati versus State of Andhra Pradesh. In this case, the Supreme Court observed that the legislature may validate an unlawful executive act, it including an unauthorized assessment of tax and with retrospective effect subject to constitutional limits. Now, here the effect of the Indian legislation by this case we can say that can be prospectively or retrospectively. After that, I will discuss a different topic, and we can say the concept of delegated legislation in India. And before explaining this delegated legislation in India, I would like to quote by the Salmond the quotation that which proceed from any authority other than the sovereign power and is therefore dependent for its continued existence and validity on some superior or supreme authority, that is delegated legislation. Here, the delegated or subordinate legislation we can say as another branch of the rule of law made under the authority of an act of parliament. Although laws are to be made by legislature, but the legislation may by statute delegate its power to other authority or bodies. In fact, delegated legislation exists in many forms such as rules, regulations, orders and bylaws. Now, if I will explain you the scope of delegated legislation, then the Indian Parliament and state legislature can delegate both administrative as well as delegated function, as well as legislative functions to any subordinate body or individual. There are some limitations given to the delegation of the legislation power. The first limitation is that legislature cannot delegate its essential legislative functions. Second one, there should be standard lying down by the authority. And the third one, what can be delegated is task of subordinate legislation. It should be ancillary to the statute which delegates the power to make it effective. And the last limitation, the judiciary cannot interfere in the discretionary power vested in the legislation to determine the extent of delegated power in specific or particular cases. to explain this legislative subject matter, if we will read Article 246 and read this article with Schedule 7 of the Constitution, then we will find that the Union Parliament in every state legislature have power to make laws with respect to any of the matter mentioned and fall within the field of legislation as given under this Article 246, read with the 7th schedule, and fall under the Part 11 of the Constitution. So, after discussing that, what is the legislative subject matter of the Indian legislative parliament system and the state legislative system, I will describe and explain the residuary power. Again, very important one, that Article 248, which confers the residuary power of legislation exclusively on the Union Parliament, and the three lists, however, do not exhaust all the legislative subjects, but Indian Parliament is empowered to pass laws on the state subject for the state, and in case of emergency proclaimed because of the failure of the constitutional machinery under Article 356, in such situation the power is come under the residuary power. And here again, my dear student, I would like to compare the Indian residuary power system with the United States of America and Switzerland. As I already told you that the residuary power have been allotted to the central government by the Constitution, but in case of USA, United States of America, the residuary power have been given to the states, and again in case of Switzerland also, the residuary power have been given to the states only. So, again, as I given you in the beginning the hint about the problem, that problem is, what if there is inconsistency between laws made by Parliament and laws made by the legislature of states? In that, I will start with the situation. The situation is, if law made by state legislature is repugnant to law made by the Parliament, or Parliament here should be competent to enact, then what will be the solution of such problems? So, to solve this problem, we will take the help of Article 254 Clause 1. Here, according to Article 251 Clause 1, the law passed by Parliament, whether before or after the law passed by state legislature, the existing law shall prevail, and the law made by state legislature shall be void to the extent of repugnancy. Here, the solution is not only enough. The one thing which should be considered by you, the condition for the applicability of Article 254 Clause 1, that is, that only in respect of any matter enumerated in concurrent list. In other words, we can say that the repugnancy between subsequent and existing law must be there for the applicability of above mentioned solution, which is given under Article 254 Clause 1. So, here student, just by this problem and its solution, so to test the repugnancy, firstly we should know repugnancy. Repugnancy here simply means such portion of state legislature which is inconsistent to central law, and in concurrent list it becomes invalid. So, dear students, I will give you the three tests which is given under the Indian Constitution. And by these tests, we can bestly check the repugnancy between the laws. The first test is direct conflict test. Here, in this direct conflict test, the situation of conflict has such kind of inconsistency, which is called direct inconsistency. You will well understand it by the example. For example, Central Act says do and the State Act says don't. It means directly, clearly there is a conflict between the two laws, and that can be checked by the legislation. And then after that we will discuss the second test, that is occupied field test. Firstly, the occupied field test will applicable only where there may not be direct inconsistency, clear inconsistency or apparent inconsistency. Now, the condition to apply the occupied field test when both the legislation covers the same subject matter. Again, its area of inconsistency between both central law and state law. For example, central law prescribed the 10 years punishment for one offence, and again the state law prescribe a 5 years punishment for the same offence. Then this inconsistency is not direct, it is indirect one, but on the same subject matter, and in such situation the occupied field test will be applied. And the third and last, and you can say very complicated test, is intended occupation test. Under this situation, the test arises with the intention of the legislature. Here, the writing, the direct inconsistency is not requirement. Here is the requirement of to know the intention of the legislature, who directly or indirectly covering the whole field. For example, if Parliament lay down an exhaustive code in respect of the subject matter, replacing the act of the state legislature with an intention to do so, in such situation, the intended occupied test will be come out. Now, dear student, we will come to the next, that is Parliament power to legislate on subject matter. Power of Parliament to enact law over a subject in state list is firstly for national interest under Article 249. Here, I will discuss the procedure for such legislation by Parliament. The first step is that Rajya Sabha passes a resolution by 2/3 majority of the member present and voting. In the second step, Parliament has power to make laws for the whole or any part of the territory with respect to the subject. And the third step is such resolution duration is 1 year from it passed. Its renewal when required, its extension can be maximum for 1 year. And the last step under this you can say procedure is laws passed by Parliament under this article, it cease to have effect on the expiration of 6 months after resolution has ceased to operate. The second situation during emergency proclaimed by the President given under Article 250. Here again the procedure is stepwise. I will explain you. Any restriction on parliamentary legislative authority in relation to the subject matter enumerated in the state list, such restrictions are removed during the emergency. In the second step, we can say that Parliament has power to make laws for the whole or any part of the territory of India with respect to that subject matter. In the step 3, such legislation shall cease to affect after the expiration of 6 months after the proclamation of emergency ceased to effect. And the next is the very, you can say that Parliament can make a laws for giving effect to treaties and international agreement under Article 253. Here again, Government of India or Union Parliament empowered to legislate in relation to foreign agreement under following entry 10 of the list. That list should be Union list, and entry 14 of the Union list. And under the same Article 253, they empowers Parliament to make any law for the whole or any part of the territory of India for implementing treaties and international agreement and conventions. Government of India implements all international commitments. Such treaties are not self-operative and not required to be ratified by Parliament. Parliamentary legislation here required for the implementation of provision of treaties. My dear student, again I would like to note one important point, that enforcement of such laws subject to the constitutional limit and cannot infringe the fundamental rights. The last one, the situation where the Parliament can legislate the laws for the state, very famous, very known for every citizen of India, and that situation is when there is failure of constitutional machinery in state under given under Article 356, when according to the Constitution provisions, Parliament declare that government of state is not functioning in accordance with the Constitution, then situation arises who will legislate and control the functioning of state. And this question will be answered by Article 356, which is the constitutional solution of this problem. And you know that Article 356 empowered the Parliament to make laws with respect to all matters mentioned in state list. So, if we will sum up the whole lecture which we discussed about the legislative relations between the union and the state, there are few important points which can be observed. The one is, there is a distribution of subject matter between the three lists. The subject assigned to the state by the Constitution. Even after that, there is not exclusive jurisdiction to the states. Then we can say that there are few subjects, and we can say that there are few specific subjects over which state has subordinate power to the center. And we have very good example of the flexible distribution of power under the whole discussion. And after that, we can also say that the powers given to the center are only in specific situations and for limited time period. That is not permanent and for every situation, that is only for specific situations. And there are Article 249 we discussed, Article 250, Article 253 and 356, who are directly relate the center and state relations, legislative relations. So, I would like to say here that the legislative relations between the center and state, though we know there is a separation of power, division of power, it is well given under the Indian Constitution, but still there are many situations, many circumstances where the exhaustive legislation is not available, and to deal with to deal with such specific situation, we have to take the help of these articles. For example, Article 248, Article 254 to 356, where we need that the center will legislate for the state. And with this, I will like to say you thank you.